Hey, Oropesa for Florida U, Judge. Thank you for tuning in. And today I have a remarkable guest that is joining me, A Wellington Barlow. And Mr. Barlow, thank you so much for joining me today.
Thanks for having me. I appreciate it.
Listen, he is going to discuss a remarkable software that he has created, been a catalyst in creating. And so, Mr. Barlow, can you tell us a little bit about the software that is just being introduced here in this state?
Yeah, well, first of all, I'd like to just tell your listening audience that I'm from Jacksonville. I'm a practicing attorney, been in the Florida bar since 1986 and been a member of the Georgia bar since 1994. And I've been practicing civil and criminal litigation. Stopped doing criminal cases actually in 2016, but I still do civil litigation. But this software that I created relates to a case that actually two cases that I tried back in 2010. And unfortunately, my client was sentenced excessively, and I was trying to explain to the judge that that sentence was an outlier, but I had no objective means by which to show him. And it was a judge who had not only been on the bench for about 2 years, 18 months, something like that, and he had no prior criminal litigation experience, was elected to the bench and everything. And I was trying to let him know that what the state attorney was asking for was too much. But you know, he, as judges normally do, they defer to the state. So he sentenced my client to the top of the guidelines. My client was 7.9 years to a maximum of 15 years, and he gave my client the maximum, despite the fact that my client had no prior criminal history, and despite the fact that he was a graduating high school senior with 2 football scholarship offers in colleges. But at any rate, when the Sarasota Herald Tribune came out with that groundbreaking study back in 2016, it reminded me of the case that I had back in 2010, because what that study showed was what we already know, which is there is disparate sentencing throughout the state of Florida. And so they highlighted that. It reminded me of the case that I had, that my client was excessively sentenced back in 2010. And within 24 hours of me reading that newspaper article, I penned a position paper called the Codification of Common Sense. And I took it to the Florida legislature in 2017, spoke to the Senate Judiciary Committee, and it was just a concept on paper and nobody understood what I was talking about. I kind of got frustrated about it actually, but within that year I met a programmer, and I explained to him what we could possibly do in terms of comparing sentences of current cases, pending cases with prior cases. And so we built a system called the Equity in Sentencing Analysis System. Had to create a corporation to promote it and everything. That corporation is called Technologies for Justice. But what Equity in Sentencing Analysis System does is it takes Department of Corrections data, 2.1 million records from October 1st, 1998 through June 30th, 2017. We're about to upload the 2017 to 2018 data over the weekend. But we have over 2 million records that we can search through at the click of a button, and you can compare apples and apples and oranges and oranges. And so when we created this software, when we created the program and everything, and we put it into active practice, when we piloted it and tested it, the first case I tested was mine. I went back to December 31st, 2010. My client was sentenced in January of 2011, so I went back and searched cases from October 1st, 1998 through December 31st, 2010, and what I found was it was exactly like I told that judge back in 2011. Nobody prior to my client had received over 8 years after having been found guilty by a jury of sexual battery with slight force. So my client was the first one that had 154 points on the guideline and was sentenced to over 8 years. And if I could have shown that judge that information back then, I'm quite sure my client would not have been sentenced to 15 years. And it added insult to injury, because our position is that, was then and is now, that he is guilty. So what, not guilty, excuse me. So what ESAS does is it can compare sentencing data, which we call sentencing precedent, and it can compare apples and apples. So if you have a case right now pending and they're trying to give your client, let's say 10 years, you can look up similarly situated cases back from 1998 up until June 30th, 2017 now, and next week, June 30th, 2018, and compare and contrast those sentences with the prospective sentence that you're negotiating with the prosecutor right now. And what we find is that the system is so powerful that when you show, we have one case in a county that we're running a pilot in right now. The prosecutor was trying to give a young man 10 years for possession of a firearm by a convicted felon, but when they used ESAS, the public defenders used ESAS to pull up similarly situated cases. They showed the prosecutor where the average sentence from that office for that type of case was 18 months. When the prosecutor saw that, he voluntarily moved his offer, reduced it down from 10 years to 18 months, and the client took it the next day. But that was the second time it was actually used in a pilot circuit that we have. The first time it was actually used was back in July. And we had a case whereby a young man was charged with 10 counts, and he was facing a minimum of 10 years to a maximum of 150 years on the CPC code guidelines. But the attorney, who was a board certified criminal defense specialist, certified by the Florida Bar, used ESAS to pull up about 4 other cases that were similarly situated, yet those cases were even worse. They had more counts, and the persons were facing more time in prison. But they had received less time than the state was offering this particular client. So the other cases received probation and community control, which is home detention. And so when the defense attorney saw that, she filed a motion for the judge to take judicial notice of those other cases, which the judge did over the state's objection. And this defense attorney asked the judge to go below the guidelines and institute a YOP, which is a youthful offender program sentence. And the judge, over the state's objection, sentenced that young man as a youthful offender, and that saved that young man a lot of time in prison. But what's most important is those 2 cases that I just mentioned, they were equitable sentences because ESAS was specifically used to pull up similarly situated cases and show the prosecutor in the second case and the judge in the first case that what was about to be done by them was going to be inequitable, it was going to be unjust, it was going to be unfair. Now, one of the things that people need to understand is the Equal Protection Clause of the Florida Constitution and the United States Constitution are always applicable with respect to sentencing when you're dealing with a situation whereby one person is being sentenced to a higher amount of time, but they're similarly situated to other persons who have not been sentenced to that higher amount of time. So for instance, if you have a situation whereby your case, your client is facing 8 years to 15 years, and everybody else is receiving 8 years, and your client receives 15 years, that is a violation of that client's equal protection rights. However, what has happened in the past is this. There's never been an opportunity for people to look back at the data before because it was just too cumbersome to do it. But now that ESAS is in existence, you can search those records. In 2.1 million records, you can come back with similarly situated cases in about 1.5 seconds.
And I've seen the system. I had the immense pleasure of meeting with you recently. You attended the Criminal Justice Summit hosted by the Florida Bar, its first annual. And so I just, without even knowing that you were in town, I called you because I'd heard about your article there was a write-up with the Florida Bar News on your system this year.
Yes.
And so a colleague of mine and an extraordinary attorney, Robert Eckerd, mentioned it to me in conversation. And so I made a mental note and I followed up and searched it. And so right around the time that you were in town, I called you and I said, hey, I'd like to have you on so that you can put out the word about this incredibly new revolutionary software that I don't think there's no other of its kind, correct?
Not to our knowledge.
Okay.
Nobody's ever seen anything like it.
I called you. I remember you called me later in the evening and you said, hey, I just happened to be in town. So we met up the next day for dinner. And, you're a man after my own heart because we had dinner and you brought your laptop. We're very techie, both of us. And and so you plopped the laptop and we ate good Cuban cuisine.
That's
while
right.
I was able to see you show me the software. It's extraordinary. I think it's a no-brainer. talking about equal protection under both our Constitution and the federal Constitution, it would be, I think, let me pose this question to you. Do you think that any defense attorney worth his or her salt would be derelict, do you suppose, if they are representing a client that the government is seeking incarceration, imprisonment? And so do you think that perhaps there may be a perception by a client that they should run numbers in the county and where the government is seeking imprisonment just to make sure that it's equal?
Well, let me say it like this. A lot of times, if you don't know what you don't know, you can't do what you can otherwise do. So unless and until people know about this, it's not going to be an issue. But once the word gets out on the capability of the system, it would be negligent to not use the system if it's within your capability to have access to it. It would be negligent.
Let me ask you this. You just, as you just related, you have a case where you still, I think I've seen two of your presentations. You did a presentation for Pactel, the Criminal Defense Association here in the county of Pactel, and then you did another one in Hillsborough,
yes,
which was hosted by attorney Frank De La Grana in Tampa, and we had Hillsborough County's public defender, Julian Holt, attend that one, and her reviews after the presentation were very positive, and I believe she's gone ahead and is one of the first public defenders in the state to go ahead and have already implemented or signed a contract with you to implement that in her office. Yes,
yeah, she's actually the second, but
okay.
Yes, yes.
Oh, one of the first ones. So
yes,
she's the
yes.
second. Okay, so you did a presentation there. I was able to see both presentations, and so you, in relating as to how this software came about, the first mover was, of course, something that still you said to the audience weighs on you to this very day, where you lose sleep sometimes because of the haunting impact that case that you mentioned in 2010 has had on you. But then compounding that with the Sarasota Herald Tribune bias from the bench coverage, that would push you into then saying, there needs to be a solution to this problem. I've seen it. It's amazing, the software. And so do you still offer, I know you were offering at those presentations, free trial for attorneys. Is that something that attorneys that may
yes.
come upon this segment
Yes,
may contact you? Where can they contact you? Put your contact information.
Technologiesforjustice.com, technologiesforjustice.com.
Phone number?
Is 855-845-3727. And that's 1-855-845-3727, which is T4J ESAS.
I'm going to go ahead and I'm going to ask you just to take a couple of minutes and just kind of explain how the process and the database usage works, and then I'm going to go ahead and put some slides on so that they can get a visual on as you're explaining how that works. But just can you do a real quick run through how that works?
Yes, what it is you pull up, once you log into the system, it'll have a statute description section, a statute section. It'll have a judge's name box. You can search by a judge's name. And it'll have a search date for offenses from October 1st, 1998 through June 30th, 2017. And then an offense date, the same, October 1st, 1998 through June 30th, 2017, soon to be June 30th, 2018. And then you have the county that you can select, or the circuit. Well, we break it down by the county in each circuit. And so what you can do is you can search by a statute description. So you can use a drop-down box and search for, let's say, for instance, sexual battery. Or if you know the statute, 794, you can put 794 in the statute box, and you put in the also the guideline points. Two boxes for that. So if you want to search a range from 0 to 99, all of the cases, and that particular statute would come up that with that search criteria. And when you select the county, you hit search, and then every case that fits your criteria is going to come up. So sometime it could be 1,000 cases, sometime it could be 5,000 cases, but we have the system calibrated to only show 1,000 cases at a time. So if 5,000 cases come up, it'll show you that 4,000 cases are there, but 1,000 are up for your review right then. And then you can start going down that list and looking at the guideline points, the sentences, whether it's probation, state prison, community control, or a split sentence, whether there was a downward departure. You can hit the case number or the docket number, and it'll pull up a digitized score sheet so you can see all the dynamics of the case, and then you can compare that case with your case. And then the way we train attorneys is to do a request for judicial notice or a sentencing memorandum with a request for judicial notice. You highlight those cases that you want to be persuasive authority for that judge to help that judge decide what your sentence should be in your particular case. The state attorney usually is going to object, but most of the time, as we've seen, the judges will overrule that objection. Or if you're dealing with a plea bargain situation, you can simply show the state attorney those cases, give them a copy of them, let them do their own research or whatever, and if everything goes well, they will see that what they're asking for is an outlier, and they can go with what has been done in the past. So that's basically, in a skinny, how the system works.
Okay, so is there anything else that you want to add regarding the system, anything that you want to enlighten the viewers with?
Yes, there is a feature that is a statistical analysis capability. So you can, for instance, filter down, you can look at the numbers of plea bargains and in a particular statute, and you can hit a button and a statistical analysis will come up, will show you the mean, the median, the maximum number of years and everything else, and then you can reduce that down to only the trials or only the pleas, or you can do a statistical analysis on the trials only, the pleas only, or a combination of the two. And this is really important because if you want to see that there's, for instance, we know that there's a trial penalty a lot of times. Whereas if you plea bargain, it's a lower sentence. If you go to trial on the same type of case, it's a higher sentence. So you can do a statistical analysis on both sides, and you will see the difference. And it's a vast difference a lot of times. Sometimes we'll see as many as a 5 or 10 year difference between a plea bargain and a person who was sentenced after a loss to trial.
Okay, well, thank you so much for coming on and providing this incredible information to the viewers. Heidio Oropesa for Florida U Judge. Till next time.
Thank you.